Hello, everyone. My name is Yifei Zhu. I am an undergraduate law student at the Zhongnan University of Economics and Law in China. The paper I will be presenting today is titled Reinterpretation of Jurisprudence of the Employment of Force, an analysis based on international treaties, international legal precedents, and doctrines. My speech today is divided into three parts. Part 1, Introduction. Part 2, Analysis of the legality of the use of force. Part 3, Discussion on the responsibility of the use of force. Firstly, I will briefly introduce the topic of my speech today. It is widely believed that all residents on Earth hate wars and are eager for peace. However, nowadays, it is common to see two or more states come into collision and even launch a great war in order to satisfy their own needs. This special phenomenon raises some questions. Is the use of force sometimes permitted under the legal system of international law? Should individuals be held responsible for damages caused by international armed conflict? What is the relationship between unlawful use of force and international crime? So today, I will focus on 2 points: legality of the use of force and issues of responsibility. Then I will talk about the legality of the use of force. The prohibition of the use of force is a well-established legal principle in international law, reflected in various international treaties, customary law, authoritative judicial decisions, and official documents of the UN. Article 24 of the UN Charter implies that refraining from the use of force is an inherent obligation of all states, and any violation of this principle will result in international legal obligations and responsibilities for the state. However, Article 24 of the UN Charter should not be interpreted as a complete ban on the use of force. There are 2 exceptions: self-defense right and forcible measures taken by Security Council. The first exception is self-defense right. It is also a legal principle in international law. According to Article 51 of the UN Charter, nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. This exception has been further elaborated in a number of cases of the International Court of Justice, and I will choose one of them, that is, Nicaragua case, to make a deep analysis. The main point of the case is that the use of force in self-defense must meet the elements of necessity and proportionality. Necessity means the armed attack is so instant, imminent, and overwhelming that it has no moment for deliberation and no choice of means for state. Proportionality means the degree of self-defense does not exceed the level of armed aggression. Besides, some articles of the UN Charter put several limitations on self-defense right. In conclusion, states should timely inform and cooperate with the actions of the Security Council. The second exception is forcible measures taken by the Security Council. According to Article 42 of the UN Charter, the Security Council is authorized to use military action such as air forces, sea forces, or land forces against another state. As part of its enforcement action. There are also some restrictions on the actions. To conclude, the Security Council is obliged to conform to the values of United Nations, fundamental principles in international law, and peremptory norms, and it must submit reports to the General Assembly regularly. Lastly, I will talk about the responsibility for the use of force. Under international law, responsibility can be categorized into state responsibility and the individual criminal responsibility. Firstly, I will talk about state responsibility. The responsibility of state originates from the fundamental principles like state sovereignty and the equal standing of state in international law. It means that if one state violates its international obligations, international responsibility will arise and consequently lead to the duty of reparation and cessation. Whether state bear the responsibility should meet elements of unlawful conduct, elements of the consequences of damage, and elements of attribution. In the situation of international armed conflict, when the actions of armed forces can be attributed to a country, the country bears the responsibility for the use of force. Then I will analyze the case armed activity on the territory of Congo. The main point of the case is that the actions of the troops were carried out with the consent of Uganda government. It can be concluded that the actions of a state organ are considered to be representative of the state itself. Then I will talk about individual criminal responsibility. The formation of individual criminal responsibility is due to a growing international focus on safeguarding individual rights and is enshrined in Article 25 of the Rome Statute. That is, a person who commits a crime within the jurisdiction of the court shall be individually responsible and liable for punishment in accordance with this statute. The Rome Statute also identifies 4 types of offenses falling within the jurisdiction of the International Criminal Court. These types include genocide, crimes against humanity, war crimes, and the crime of aggression. Besides, in international armed conflict, superior responsibility, also known as command responsibility, is the sole form of individual criminal responsibility. This implies that military superiors may be held accountable for crimes committed by the forces under their authority if they fail to exercise appropriate control over them. However, there are still some questions remain. For example, the question of whether state officials, such as presidents, should also bear individual criminal responsibility remains a topic of debate. There are some typical events. For example, former Iraqi President Saddam was convicted of crimes against humanity and sentenced to death by the Iraqi High Court after Persian Gulf War. During the Russian-Ukrainian War, the International Criminal Court issued an arrest warrant for Russian President Putin. As a result, more academic and practical issues related to international criminal responsibility need to be further explored, rationalized, and legitimized analysis and interpretation. so as to form a wide range of consensus in the international community. Thank you for your attention. If you have any questions, feel free to ask me.